Good afternoon, everyone. We're so pleased you've been able to join us today for special litigation committees in limited liability companies. If you'd like to minimize the GoToWebinar dashboard, just click the orange arrow to the left of the control panel. All attendees are muted for the presentation, but if you have a question you'd like to ask, please go to the questions drop-down on your control panel. We're collecting all the questions to be answered after the conclusion of today's webinar. There are also handouts available in the control panel if you'd like them today. We have follow-up emails coming out on Friday, which will also include a link to the handouts. We thank the University of Florida Levin College of Law Institute for Dispute Resolution for co-sponsoring our CLE webinar series. Now to our presenter. We have Donald J. or Don Weidner, mediator and arbitrator with Upchurch, Watson, White & Max, and Dean Emeritus, Florida State University College of Law. He served as a gubernatorial appointee to the Uniform Law Commission from 2011 to 2023 and was the Commission's reporter for the revised Uniform Partnership Act of 1994. He is also an elected member of the American Law Institute. Sorry, my notes are. And he serves on its members consultative group on the restatement of the law of corporate governance. He gave a similar talk to the one he will give today for the Florida Tax Institute earlier this year in Tampa. And you can go ahead, John.
Well, thanks very much, Kathy, and thank all of you who are attending. We've done, Kathy and I have done a show like this before, and she says that the people love it if I pack in a lot of information. So I will try to pack in a lot of information for you. Slide 4 begins with an overview of what we'll discuss during this hour. We'll first consider Florida LLC Act's provisions on when a dissatisfied member of an LLC may bring a direct claim against another member, against a manager, or against the LLC itself, or whether that member will be denied a direct claim and be treated as having merely a derivative claim on behalf of the LLC. And we'll see that the basic concept is that a member's claim may be considered derivative, merely derivative, because the operating agreement is not treated like an ordinary commercial contract. Point number 2, if a member of an LLC brings a derivative action on behalf of the LLC has the right to respond by creating a special litigation committee to determine how the derivative claim should be handled. Number 3, we'll look at the Florida LLC Act non-uniform provisions regulating derivative action, including the fact that Florida has, I think to its credit, disinterest and independence requirements, both for SLCs and for those who appoint the SLCs. And I think also to its credit, we'll see that Florida courts have by statute have discretion to adopt the SLC's recommendations. Slide 5 continues the overview, noting that we'll consider the judicial standard of review of the composition and work of SLCs, with special emphasis on Delaware. And we'll see that the Florida courts have looked to Delaware already on matters concerning SLCs. I'll suggest that the current default rules for dispute resolution within LLCs are not suited to small, closely held LLCs. For this reason, some other states have reached the same policy conclusions. Some states exempt closely held LLCs, both from the imposition of the direct derivative distinction and from the other complexities of derivative litigation. Some states, such as Texas, do so by statute, others do so by judicial rule. In this respect, these states make the default dispute resolution rules of LLCs the same as the default rules in the case of LLPs. That is, these states, in effect, provide LLC members with easy access to judicial remedies. Time permitting, and I think there may not be time permitting, we'll take a deeper dive into dinero, which is Florida's leading case distinguishing direct claims from derivative claims. I guess the good news is I have very thorough slides on this point, on this subject. I guess the good news is also that I don't plan to cover all of these today, but I'll leave you with in effect, with a research device that near the end looks at more at some of the particular Florida cases distinguishing a direct claim from a derivative claim. So slide 6 indicates that Florida's LLC Act is based on the revised Uniform LLC Act, which I'll refer to as RULCA. The bulk of slide 6 is the first part of Florida's direct action provision. And it begins by saying subject to subsection 2, and that's a huge qualification, as we'll see. So let me put that aside. That's on the next slide, and just consider this the basic concept. What are we saying here? That subject to subsection 2, a member maintain a direct action against another member, a manager, or the LLC to enforce the member's rights, either 1, under the operating agreement, 2, under the LLC Act, or 3, arising independently of the membership relationship. Now, the word standing does not appear in the text of the statute. Nevertheless, this threshold question of does the member have a direct action, that question is generally discussed in terms of whether the dissatisfied member has standing to bring an action on his, her, or its own behalf, or rather, is the member relegated to bring a derivative action. So the big question then is, how does subsection 2 limit this very broad statement that a member has standing to bring direct action? And those limitations are contained on slide 7, which has the second part of Florida's direct action provision. By the way, I won't simply be reading statutory sections throughout, but I think part of what I can do for you, for those of you who are relatively new to this, is make the statutes come alive a little bit by talking about both their specific details and by the policy ideas behind them. So this subsection 2, the big qualification, says that a member maintaining a direct action must plead and prove either an injury that is not solely the result of an injury suffered by the LLC, or an injury resulting from a violation of a separate statutory or contractual duty owed, even if the injury is in whole or in part the same as the injury suffered by the LLC. Now, again, Florida's LLC Act is based on RULCA. This provision I've just quoted to you on slide 7 is a non-uniform definition of a direct action. The short of it is RULCA only has part A here. This has part B. This subsection B says it's okay if you can prove an injury resulting from a violation of a separate statutory or contractual duty owed, even if the injury is in whole or in part the same as injury suffered by the LLC. That is a non-uniform definition. It's a more inclusive definition. It's an attempt to codify the Third District Court of Appeals opinion in the Dinero case, which I've cited at the bottom of slide 7, and that's Florida's leading case. It's a massive opinion, and it goes back. It attempts to look at all the Florida and other law, much of the Delaware, on the distinction between a direct action and a derivative action, and now this attempt to codify Dinero is not one that everyone is happy with. So there's some discussion within the Florida bar that this provision ought to be amended again. And so we'll look more at Dinero and the extent to which the statute does conform to Dinero. So before making any finer distinctions, let's highlight what's clear in this area. So at the bottom of slide 8, you can look at example 1, which says that a dissatisfied member does have a direct claim if management has singled out that member or targeted that member with misrepresentations, or excluded that member from notice of meetings or from distributions that all the other members are receiving. So that's a direct claim. There's a unique violation of that member's rights, and that member has a direct claim, and any remedy for that claim goes to her as a general matter. By contrast, a dissatisfied member does not have a direct claim if all she's saying is simply that the management of this LLC has been terrible, and the management has driven down the value of the LLC and hence the value of her interest. She may be able to bring, if not a direct claim, a derivative claim on behalf of the LLC, because all she's saying is that my injury, her injury, is derived from the injury to the LLC. Now, in that case, again, classically, any remedy on this derivative claim would go to the LLC. We'll see that's not always the case, and when we talk a little bit more about Dinero. So what's going on? I think the basic argument supporting the limiting the actions, limiting the direct actions that can be brought by members of an LLC, tend to be traced to the shield, and whether that's accurate or not, and I question it because the shield is almost identical to the shield in LLPs. This much is clear. The statutory drafters of the LLC Act clearly intended that the operating agreement should not be treated like a, quote, an ordinary commercial contract. Now, let's look at the shield and then what the statute says, and then step back and try to figure out what it means and what it doesn't mean. So the bottom of slide 9 contains Florida's LLC shield, and it has belt and suspender provisions. Okay, the belt is in subsection 1. A debt or other liability of an LLC is solely the debt or other liability of the LLC. All right, that's the belt. The suspenders is a member or manager is not personally liable for a debt, obligation, or other liability of the company solely by reason of being or acting as a member or manager. So you can say, well, what is the essence of the shield? The essence of the shield is that it eliminates the vicarious liability of a member or manager for the contracts or torts of the LLC. Slide 10 first indicates what the shield does not do. I think everybody agrees with the general proposition at the top of slide 10 that the shield does not absolve a member from liability from his, her, or its own wrongdoing. However, I do want to point out, since Dinero is the most famous case in Florida on this point, Dinero states that the LLC Act, quote, specifically provides that members are typically shielded from individual liability for their involvement with an LLC. I think that's an overstatement of the effect of the shield, because that statement ignores liability that members and managers can have for their own wrongdoing. However, despite that overstatement, Dinero does correctly capture the intent of RLCA and of the Florida drafters, that the operating agreement is not to be treated like an ordinary commercial contract. Now, such an important point. Slide 11 contains the official RLCA comments to that. And again, it's talked about in terms of standing. The official comments to RLCA 801 explain that the operating agreement typically provides a member with less, quote, standing to sue for breach of contract than an ordinary commercial contract. And the comment explains, think about it, in ordinary contractual situations, if you have a multi-party contract, it's axiomatic that each party to the contract has standing to sue for breach of that contract. And then the comment says, without really, I think, explaining, within an LLC, different circumstances typically exist. And says a member does not have a direct claim against the manager or another member merely because the manager or the member has breached the operating agreement. And likewise, a member's violation of this act does not automatically create a direct claim for every other member. Slide 12, Dinero explicitly adopts this view that a member does not owe a direct duty to other members simply by being a member or signing the operating agreement. So unlike a typical, what do we have now? 55. Unlike a typical bilateral contract where both signing parties owe duties to one another, operating agreements established, in Dinero's words, a more complicated and nuanced set of contractual rights and duties. Now, Dinero then went further, and again, this is the major case in Florida on this distinction, direct derivative distinction. Dinero stated a presumption that members are not directly liable to one another for promises they make in the operating agreement. The presumption can be overcome, but by a provision stating that the members shall be directly liable to one another for breach of its terms. Now, in slide 13, the Dinero admits that the statutes and operating agreements are often confusing on who can sue whom and for what. All right, and the quote there near the top of slide 13. Unfortunately, many operating agreements and statutes do not specify who owes a particular duty and to whom that duty is owed. Indeed, they look at the Florida LLC Act, which is similar to the same as on this point as the RLCA. The Florida Act subjects all managing members to a duty of loyalty and care that is owed to the LLC and to all of the members of the LLC. The operating agreement may not unreasonably restrict the right of a member to bring a direct action. However, it's a default rule, and Dinero confirms that nothing prevents an operating agreement from expanding the right of a member to bring a direct action against another member, a manager, or the LLC itself. And what I would add here is that but you better be, if you want to do that, you better be clear about it. So slide 14 says, look, this is a broader issue apart from the direct derivative distinction. There's a fundamental drafting point I address here on slide 14 in the context of LLPs, the quote from the book I have with Bob Hellman and Alan Don. It says, look, when you're drafting these agreements, you better make clear who the agreement is with. If I sign an operating agreement, am I making an agreement with the firm, or am I making an agreement with the other signatories or deemed signatories of the operating agreement, or both? And so, suppose I am a member of an LLC or an LP, and I have three fellow owners, three fellow members, Mo, Larry, and Curly, and I sign. And and Mo, Larry, and Curly and I all sign the operating agreement, which says that I, Don, am to get $1,000 when I retire from the LLC, and I retire, and I go to LLC management, which is in the hands of Mo, Larry, and Curly, and the LLC doesn't pay me. Can I sue Mo, Larry, and Curly? That's in effect the question that came up in this famous case I've cited on slide 14 of Eder v. Gursky. Mo, Larry, and Curly said, oh no, Don, you can't sue us because of the shield. And the shield insulates us from any liability to you. And the New York Court of Appeals said, no, you, Mo, Larry, and Curly are wrong. What the shield does is insulate the members of the LLC from liability to third parties. It doesn't protect you from liability to the other owners, members of your firm. If there's an LLC case interpreting the shield the same way as in Eder, the domain associates case, and again, it's saying, so the point is, if you want to insulate yourself from liability for a claim by another member inside your firm, you better make clear in the operating agreement that person is shielded. So why do you do this? Slide 15 has a summary of the policy arguments for limiting direct actions. And again, the history of these kinds of provisions is from corporate law, and so it's particularly easiest to see these policy concerns if you think about GM or Meta. You think of a very large firm, public firm with many members. And one argument is to preserve the role of the firm and its managers and members in resolving claims of the firm in accordance with their best business judgment. And that's particularly easy to see in the case of, think about claims to outsiders, claims against outsiders, and that it might be that the firm has legally a cause of action against an outsider, but decides in its exercise of business judgment it's just not worth pursuing. And so you do want a system that lets that defers to the business judgment of the firm. It also the distinctions also serves to prevent multiple suits over the same cause of action. And I mean, what if the General Motors shareholders all over the place are suing? The direct derivative distinction says no. What's really at stake here is not a direct claim by you if all you're saying is the company's been mismanaged, and to also to fairly distribute a recovery among interested members. If they're bringing separate lawsuits, then you don't want one to recover more than that person's share, and also to avoid prejudice to firm creditors. So the idea is that you don't want insiders to suck, by making derivative claims, to suck money out of the corporation and therefore leave it in a position, a poorer position with which to pay off firm creditors. So I submit when a member is suing a member for breach of fiduciary duties, and when all the members are parties to the suit, and certainly in the claims against insiders, and everybody's a party to the suit, these policy provisions drop away, and indeed some states have said so by statute. So those are the ideas. Slide 16 indicates that the law of LLCs has turned its back on the law of LLPs, even though despite the shield has virtually the same belt and suspenders, the RUPA, it's clear that the Revised Uniform Partnership Act, which Florida adopted, it's called FRUPA in Florida, anyway, intended to eliminate present procedural barriers to suits between partners and explicitly provided for, quote, direct actions against other partners or the partnership, quote, for almost any cause of action arising out of the partnership business. All right. So RUPA explicitly provides, even for the shielded LLP, great access to direct actions, and so it's a very different outcome, even though some LLPs look very much like some other LLCs. Anyway, so slide 17 going on answers the question: suppose a dissatisfied member has no standing to bring a direct action. May that member bring a derivative action? And the statute says that a member may maintain a derivative action if the member first makes a demand on the company to take action, and there's no action taken by the company within a reasonable time not to exceed 90 days, or a demand would be futile. And so slide 18 indicates this demand futility requirement. And basically what it says is, if I'm Don and I want to sue Mo, Larry, and Curly for their what I think is their negligence and breach of fiduciary duties to the firm and to me, and they're controlling the LLC, and they're not going to sue themselves, right? They're not going to have the firm they control sue themselves. And so the idea is, in those instances, that demand is excused. You can go ahead and file the derivative action, and you're excused from making that demand. I sure want to point out, there's this Stu Cohn and Stu Ames, the Stews, have this Florida Business Law Annual. It's a thick paperback book that has that is updated every year, and it has annotated Florida business law statutes, and I find that an extremely helpful resource. And anyway, the Cohns, the Stews, the Cohn and Ames book says that under Delaware law, to excuse a demand based on futility, the shareholders must allege particularized facts creating a reasonable doubt that the directors are disinterested and independent, or the challenge transaction was a valid exercise of business judgment. So I have to be specific if I want to say that demand is excused in the case of me bringing an action against Mo, Larry, and Curly. So slide 19 indicates that an LLC has a right to respond to a derivative action by appointing an SLC to investigate the claims asserted in the derivative action and to determine whether pursuing the action, okay, now here's the standard, to determine whether pursuing the action is in the best interest of the company. So, so if the company appoints an SLC on motion, except for good cause, so the court may stay the derivative action. So that's the idea. The court stays the derivative action, and it says that let the SLC go and make its study and issue a report and come back to us and tell us what its recommendation is. and we'll see that under the Uniform Act, if everything is done properly, then the court must implement the recommendation of the SLC. Florida has a non-uniform provision, and it says the court may implement. So what's the idea here? Slide 20 shows the basic purpose of the SLC according to the Uniform Law Commission, and it says it can serve as an ADR mechanism, an alternative dispute resolution mechanism. Help protect the agreed upon arrangement from strike suits, protect the interests of the members and other plaintiffs or defendants, if any, and bring any judicial decision the benefits of a specially tailored business judgment. So now, so what do you think about an arbitrator? What's the difference between an arbitrator and a special litigation committee? And most of the special litigation committees I've seen are composed of just one person. But so an arbitrator is generally not tasked with exercising his or her own business judgment. Generally, the arbitrator finds facts and applies law to the facts, and the business judgment rule is part of the law the arbitrator applies. And so this idea of bringing to the decision a specially tailored business judgment, I think that stems, you can see that the most clearly in the case of a corporate law, large corporation. And we'll see the way this all came about in the corporate area is that corporate statutes have a rule that says that essentially that the directors shall manage the corporation, or it should be managed under their under their oversight. Excuse me. And so what happens if you want to challenge something that the directors have done? Well, the way it works in the corporate area is, and we'll see a big case in this, Oracle, is that if all the directors were involved in the challenge decision, then what the directors would do would be appoint, let's say what they did in Oracle, appoint 2 new directors, 2 new people to the board of directors, so that those people could then form a subcommittee of the board of directors. And the idea is that subcommittee of the board of directors was exercising its judgment on behalf of the firm. So in any event, SLC SLC in an LLC is somewhat different. An SLC must be composed of 1 or more disinterested and independent individuals. So whoever is appointed must be disinterested and independent. And disinterested is generally defined as lacking a financial interest in the outcome, and independent is generally defined in terms of being socially and politically neutral. Excuse me. Now, note that you don't have to be a member of the board, if in the most LLCs don't have boards, but you don't have to be a member at all. So you could be any one person or any group of people. You don't have to be members. You do have to be disinterested and independent. Now, what Florida adds to the RULCA is these non-uniform provisions requiring those who appoint the SLC to themselves be disinterested and independent. And that's a huge improvement over RULCA. RULCA actually provides that in certain situations, the SLC may be appointed by a majority of the defendants in the action. And that seems crazy to me, but that's why, Florida has changed it. Florida has, it's a very sophisticated business bar, and they make many very good modifications to Uniform Acts. And so anyway, the bulk of slide 1 indicates that what the Florida statute on who may appoint an SLC, distinguishing between member managed firms and manager managed firms. So slide 22 contains the explanation of the Florida Bar Drafting Committee about Florida's non-uniform provision, and you can read that at your leisure. You can send copies of it to your family. They might make wonderful holiday gifts. But so I'll skip ahead to slide 23, and slide 23 indicates that the test is what is in the best interest of the SLC. Okay, after appropriate investigation, a special litigation committee shall determine what action is in the best interest of the LLC. It's not determining who should win as a matter of law, which I think ultimately is what arbitrators generally determine. So the idea is that the SLC ought to be somebody who's qualified to assess what's in the best interest of the SLC. And anyway, so then the SLC, usually a person, makes a determination and then files with the court the statement of its determination, and there's a supporting report, and everybody gets a copy of that. Slide 24 indicates that unlike ROLCA, Florida statute gives the courts discretion to enforce the SLC determination. Unlike ROLCA, which provides that the court shall enforce the recommendation of a properly appointed and operated SLC, Florida statute replaces the shall enforce with may enforce. That is, replaces the shall with may. So I'm going to look at slide 25. I think it might be helpful if you ever get into this of setting up an SLC. It takes us to the Tenea case, and the court says, look, this is a textbook example of how an LLC should proceed. And this 2020 opinion followed years of extensive litigation, largely between a dissatisfied member of the LLC and a managing member. The LLC moved to appoint an SLC to investigate the derivative claims and figure out what to do with them. And the trial court granted the motion. And so think about it. So what do you do? Suppose you're dealing with a closely held SLC, and you may want to make sure that both, you don't run afoul of the provisions that say both the SLC and the people appointing it have to be disinterested and independent. What do? You go to court and move the court to have someone appointed as the SLC, and in this case, as an attorney, I think Tampa attorney Peter King was appointed to serve as the SLC. When the trial court made the appointment, it said, okay, and the SLC, Peter King, can engage persons necessary to assist in the SLC in carrying out its duties, and SLC King, attorney King, engaged his law partner to help, and the court said, that's fine. Now. And so what I'm trying to caution people about is here, if you're going to challenge the SLC as being disinterested and independent, do it early on, because nobody likes to waste time and money. If you wait until the SLC does a lot of work and presumably runs up a big bill and files a report, you don't want to wait until the 12th hour to challenge the disinterest and independence of the SLC. Anyway, about a year later, on slide 26, about a year later, the SLC filed its report, a 59-page report, hundreds of pages of supporting exhibits, and it concluded that, again, the standard for it is that pursuing the derivative claims was not in the LLC's best interest, and it recommended dismissal of the actions. Right, so that's a year later after the SLC does work. On a motion to enforce that report and set the matter for the hearing, the dissatisfied member objected to the report and moved to continue the hearing to permit discovery concerning the independence, objectivity, and reasonableness of the report. And slide 27 indicates the court said no. First, it said we're going to look to Delaware law for guidance on this how to treat this SLC, and the second DCA said, well, you don't get any discovery. The note that the Florida LLC Act does not require a trial court to allow discovery from the SLC. Trial courts have wide discretion in discovery matters, and the SLC contest in particular, the trial court's discretion is particularly appropriate because at this point, discovery is intended more as an aid to the court than it is as a preparation tool for the parties. What a smackdown. And you know, the court might want limited discovery, but we don't need it. And so there's not going to be any discoveries. The SLC was very careful analyzing those issues, independence, the independence issues at the front end, so the SLC doesn't wind up on the back end without having been accused of that. And the SLC, the person, Mr. King, testified on these matters at a hearing and was cross-examined. That's good enough. So then the slide 20 then says, okay, what's the composition and work of an SLC? If it's challenged, what is the standard of judicial review? And so slide 28 quickly summarizes one end of the spectrum, and that is the New York end. And it has a very differential standard of review, as laid out in the famous Auerbach case. It says, look, the SLC merely presents a special instance of the application of the business judgment rule, and we'll see if the business judgment rule is satisfied. That's good enough for us for New York. The Rulka comment says that courts should follow Auerbach rather than Zapata, which I'll talk about in a moment, citing its provision that the court shall enforce the recommendation of the SLC. However, as I pointed out, Florida rejected that Rulka rule and states instead that courts may implement the SLC recommendation. So I think even if you were going to take assuming you do take the comments as persuasive, that was a persuasive, the comment that you should follow Auerbach rather than Zapata, it was traced by Rulka to the rule that gave the court no discretion but to follow the recommendation of a properly constituted and operated SLC. Now, slide 29 introduces the other end of the spectrum, the much less deferential standard of review as announced by the classic Zapata case. And so again, Florida on these SLC issues has looked to Delaware again. I think under the statute, they're free to look to Delaware. And so Zapata just didn't like Auerbach at all, and the court said so. And it said, look, their deference to the business judgment rule means that the ultimate conclusion of a properly constituted SLC is not subject to judicial review at all. It is no review under Auerbach. And Zapata said, I'm sorry, but we're not going to rule out a closer standard of review, because when the plaintiff, when Don has been excused from making a demand on Mo, Larry, and Curly, there is sufficient risk in the situation that the court must do more. There must be more inquiry than the court has got to do more than rubber stamp it by citing the business judgment rule. So slide 30, excuse me, Zapata says we should not do what Auerbach did. New York said, look, yeah, there's an inherent risk in the corporate form that one board member will be hesitant to proceed against another board member. That's a risk. That's just a cost of doing business. The New Auerbach says, suck it up. That's a cost of the corporate form. And And Zapata says, no, wait a minute, this is a very big deal. Directors are passing judgment on fellow directors. And especially, as in the classic corporate model I laid out, especially those who appointed them to the SLC. And so Zapata says the court must have discretion to look beyond independence, good faith, and reasonable investigation of the SLC. Over in slide 31, Zapata says that the essential key in looking further beyond those things is for the court to use its own business judgment about whether the derivative lawsuit ought to be dismissed according to the SLC's recommendation. Now, people have been very critical of Zapata's articulation of that. I think I've got cited in here. Subsequently, one of the Vice Chancellor Strine said this is oxymoronic. You know, courts don't exercise independent judgment. He didn't say it this way, but he said, courts, judges, they come to work in black robes. These are not business people, normal business people. They're not business people, and so it's funny to talk about it as exercising their independent business judgment. I think I tend to locate this in with the Zapata in with the cases that say. The business case that say, even though something is technically legal, a court of equity won't let it stand. All right. So slide 32 indicates that. So I think whether you adopt Auerbach or Zapata, the two tend to come together if you're very strict about the independence requirement. All right, and the high watermark on that against the Delaware case, and the Oracle company case, and it is fascinating because some of the nation's most prominent and respected lawyers and professors got involved in this case, and everybody knew that the people appointed to the SLC had to be disinterested and independent. And the short of it is, and Oracle involved a plaintiff shareholder suing its trading directors, who claim they should be sued for breaching their fiduciary duties by engaging in insider trading. And the SLC did its work and said no. No, that's so the suit should be ended. And anyway, I know I'm coming close to the end of my time. So slide 31 indicates some of the basic facts. I mean, I probably put too much of this in an article I cited, just because it's great legal gossip. I mean, one of the trading directors was one of the richest. It was Ellison, one of the richest men in the world, in America certainly. And one of the trading director, another trading director, was a professor at Stanford. Two Stanford professors were selected to be appointed to the board so that they could serve as the SLC. One was a professor of computer science. The other was a distinguished law professor and expert on corporate governance, and he had previously served on the Securities and Exchange Commission. Now, the two recruited primarily by the two trading directors, by two of the trading directors, one of whom was a distinguished economics professor at Stanford, who had previously served as chairman of the President's Council of Economic Advisors. And so while they were wooing him to join the board, Professor Grundfest conducted his own due diligence, which gave him sufficient confidence he said, to join the board. And slide 34 indicates that the Vice Chancellor Strine said, look, you came back with a 1,000-page report that's shockingly insufficient on the independence issue. So And he said, look, and everybody knows what the Delaware test for independence is. And it's whether it depends on whether a director is at the bottom of slide 34 for any substantial reason incapable of making a decision with only the best interests of the corporation in mind. So, and he said, look, everybody knows that's the test. The problem is nobody knows how it'll be applied. And so he said, you got to take slide 35. You got to take the contextual approach to independence and consider the function of the SLCs. He rejected the idea that its members are independent if they are free from domination and control. These people say, well, we're distinguished professors. We do get top salaries. We have tenure. We've got to kill somebody before you get rid of us. And we do a lot of consulting. We're rich on our own. So we're financially independent. We're not subject to the dominion and control of the board. And the court said that domination and control is not the test, and we're not going to look solely through economically consequential relationships. We're going to consider the social situation of nature of humans. So slide 36 says, what are you talking about context? And they say, well, look, this is a very difficult decision. The question in this case is whether to sue a person for insider trading. And that's a much tougher decision than simply to sign off on or veto a proposed course of action, and the heavy responsibility of such a monumental decision, subjecting Ellison and others to claims for personal liability. It falls on in this case, two people, and the liability in part will require an inquiry into state of mind. So these are terribly tough decisions. So slide 37 said the SLC had the burden to show the absence of a material fact question about their independence. And the independence inquiry, the short of it, the independence inquiry was would the Stanford connections here, Ellison was one of the biggest donors to Stanford, would the Stanford connection be on the mind of the SLC members? And even if there was no bias, would it be on their mind? And they said, well, no, the dean raises money, the president raises money. We're professors. We just take in money. We don't raise money for the school. And no, they said this would be slide 38 says, look, the shareholders should not be forced to rely upon SLC members who must put aside personal considerations that are ordinarily influential in daily behavior. So it busted them. This very successful corporation, these entrepreneurs and lawyers and professors, they all got it wrong how to apply this this disinterested independence requirement. So slide 39 shows. So it's talked about some of the many rules that some states exempt closely held entities from the rules of derivative litigation. Texas, for example, exempts LLCs with fewer than 35 members from most of the restrictions on derivative litigation if the claim is against a governing person, member of or officer of the LLC. So if it's an inside claim, it's a claim against insiders, you're exempt from most of the restrictions of derivative litigation. And also, in such a case, the Texas statute said if justice requires, a derivative proceeding may be treated, the court may treat it as a direct action brought by the member for the member's own benefit, and the recovery in a direct or derivative proceeding by a member may be paid directly to the plaintiff or to the SLC if necessary to protect the interests of creditors or other members of the SLC. Now,
Don?
Yep.
We have about 5 minutes until the CLE number gets read out.
Okay, I think I'll do it. So I just want to point out, so I've cited Maine, slide 40 indicates that Maine has taken a similar approach to Texas. the American Law Institute has long stated that, look, the court said, the ALI says, look, if there's no policy purpose being served by imposing the distinction, get out of it. If you're not going to unfairly expose people to a multiplicity of actions or prejudice the interests of creditors of the corporation or interfere with the fair distribution of recovery among all interested persons. Slide, if you want to see more about it, slide 41 states that some courts have applied the ALI approach both to corporations and LLCs, some specifically noting that the ALI approach exempts the plaintiff from the rule permitting an SLC to recommend dismissal of the suit. The Alabama legislature cited the ALI approach when it supplemented its direct action statute simply to provide that a member may maintain a direct action to enforce a right of an LLC if all members at the time of suit are parties to the action. If it's so Alabama said it's a small, there's a small number of members and they're all part of the action, then that's sufficient protection against the multiplicity of actions. So I've cited my article there, and I said, look, it's this complex machinery of these, direct derivative distinction and all these other questions that come up. It's unnecessary and it's costly to go through all this stuff. And again, I'm sort of talking about slides 41, 42, and 43 together. So, but you can look in slide 41. So I came out with this article last year in the Business Lawyer, and the co-author, I guess the co-reporter on the Uniform Act said, this is destructive. This is terrible. This is, radical. This is crazy stuff. Saying this and in response to my article, but not joining discussion with, Texas has been doing this for 25 years. And Texas is a lot like Florida, some very sophisticated lawyers who are very active in law reform, and they've had their rule for decades, and they apply it to both SLC and corporation. So the sky isn't going to fall if you treat closely held LLCs differently than you treat large corporations. So, and again, the costs of these rules are very can be very great. Just you can read the remaining slides that show you some of the litigation involving 2-member LLCs, 3-member and 4- and 5-member LLCs getting caught up in litigation about whether the claim is direct or derivative. So the Dinero case on page 45, I guess I can stop about here, Kathy. So that summarizes what the Florida case law rule is. That famous case says that their summary is that on 45 they say a direct action may be brought only if either there is direct harm plus special injury, or if there is a separate duty owed. So just eyeballing that, you can see where that subsection B of the Florida statute came from, the non-uniform provision came from, an attempt to codify this. Is that it, Kathy? Am I done?
Yeah, I'm going to go ahead and read the numbers and
okay.
All right.
Well, then I just want to close by thanking everybody who, it looks like there's still a bunch of people in attendance. So God bless you all for sitting through this. I know it's tough, but again, you can call up the slides in the future and call up you can hear the webinar again if you like. Thank you all for attending. And Kathy, thank you too for taking us all through this.
Sure, no problem. On the final slide, if you are a Florida attorney, please jot down the Florida Bar course number so you can post your CLE credit online. It is 230-479-4, N as in Nancy. Again, that's 230-479-4, N as in Nancy. We're building our webinar schedule for the remainder of 2023. Please watch your email inbox for news about our future programs. Next is From Inception to Approval, Successfully Mediating Class and Mass Actions with Lance Harkey, Pam Perry, and Rodney Max on June 22nd. And there's contact information for both Dawn and me if you have any questions about any of the content, course number, webinar recording, anything like that. Thanks everyone for being here.
Thank you.